Hey, everybody, Al Iverson here, and I am not a lawyer. And Mickey Chandler, you are a lawyer, however, is that correct?
I am. However, Al, I am not your lawyer, nor am I the attorney for anyone who's going to be listening to this. If someone wants to hire me as a lawyer, I'd love to talk to them. But uh, as with everything, law is very fact intensive, which means anything I say here should just be considered general advice for educational purposes, as opposed to my commentary on what you should or should not do.
So now that we've got that out of the way, that neither of us are your lawyer, and I'm not anybody's lawyer at all, ever, because I am not a lawyer, but Mickey is, and he's a good person to talk to about things going on in the law. And one thing that I've been getting a lot of questions about lately, Mickey, is this new Texas Senate bill, SB140, that covers SMS marketing. It's a broadening of the existing state business code to take soliciting requirements, things that marketers are supposed to do, and apply a new set of rules to SMS marketers. And there's some kind of scary stuff there that people are freaking out about in the requirements, like a $10,000 bond, proactive registration with the state of Texas. Mick, I was wondering, tell me about this law and what is it? Where did it come from, and what the heck's going on here?
All right. So last year, there was a Supreme Court decision, Facebook or Meta versus, I can't say the guy's name. I think it's Duguid, Duguid, that had to do with the TCPA, the Telephone Consumer Protection Act, and that law's definition of what an automatic telephone dialing system was. And the Supreme Court really narrowed things and said that certain things aren't really covered by the TCPA. When you have something like that happen, states love to step in and start to regulate, where all of a sudden they have free reign to do so. We've got something in the law that is called the kind of the dormant commerce clause, which basically means where Congress has legislated, states don't really have the opportunity to do that unless the law specifically gives them the right to do that. The TCPA is, in fact, one of those laws. But where we have this definition of what an auto dialer is that has been greatly narrowed, states love to come in and say, we like the way it was before, we're going to broaden things back out. What we did here in Texas, and I am in Houston, what we did here in Texas was this SB Senate Bill 140, which went through and basically redefined what a telephone solicitation is. And it takes an existing bit of law that deals with basically telemarketing and expands the meaning of a term, namely telephone solicitation. So now, instead of saying that a telephone solicitation is a telephone call, instead, the legislature removed the word telephone and added that it means a call or other transmission, including a transmission of a text or graphic message or of an image. And so that really, when people saw that, they thought, oh, this deals with text messaging, because now we're not just talking about a telephone call with words. We're dealing with things that are in written or a visual format. So that's what really caused people to freak out about.
So these new requirements, and I'm gonna flip the order of this a little bit, and I think I'm gonna jump to the almost to the end point and then back to the middle of it here. But there was the Attorney General, their office, the Texas Attorney General's office, put out a statement basically undoing much of this, right, and kind of leaving it in a legal limbo, saying that the state of Texas doesn't believe that SMS marketing is prohibited or restricted by this law. I think they said that SB 140 does not proscribe their conduct, which is confusing to me. I mean, so now does the law cover text messages or not? And What's actually going on with that? How does that get settled?
Right. So the answer to that rests, like everything else, the devil's in the details. The detail here is in section one, the amendment to the existing law adds a new definition. It says 6-A. Telephone call has the meaning assigned by section 304.002. Telephone solicitation means a call, even though it doesn't say telephone call anymore. What the Attorney General is saying is you need to go and look at Section 304 instead of where this one is, which is in Section 302. And this is all in the context of a lawsuit that was brought by the E-commerce Marketers Alliance. That lawsuit basically was suing the state and saying, whoa, you can't do this for a variety of reasons. But it was because of their fear that this bill was going to basically cover everything text related. The Attorney General, in its response, which is what has everyone kind of breathing a bit of a sigh of relief, but is also a little bit confusing, and basically says two different things. One of those is, if you look at it, it says a call. A telephone call is a call, duh. But the other thing they do is they point to this bit here where it points over to what another one of the sections says. So the definition in Chapter 304 of the Texas Business and Commerce Code says a telephone call means a call or other transmission made to or received at a telephone number, and then gives three different things. So including a call made by an automated telephone dialing system, including a transmission to a fax machine, and then also a call or other transmission, including a transmission of a text or graphic message or of an image to a mobile telephone number serviced by provider of commercial mobile service. But at the end of that, it says, except that the term does not include a transmission made to a mobile telephone number as part of an ad-based telephone service in connection with which the telephone service customer has agreed with the service provider to receive the transmission. That's a very long-winded legal way of saying if they opted in, it doesn't count. Definition in Chapter 302, it says it doesn't cover things that are solicited. And since the plaintiff here says we only send solicited text messages, then it says it seems to us that their services are specifically exempted from regulations reaching telephone calls in Chapter 304. I think that's probably correct. And I think a lot of folks can breathe a sigh of relief. But there are a couple of downsides here. Number one, first of all, we don't have a judge saying that. Judges saying things as opposed to parties saying things. You'd rather have a judge say something than one of the parties. Even a party as powerful as the Attorney General of the state. What that does tell you, though, is a very likely direction that the state will take in enforcing the law. In other words, if they see consent, they are probably not going to enforce. On the other hand, one of the things that SB 140 does is amends things to declare that this is a deceptive trade practice in Texas. And what that means, among other things, just like every other state, is that there's a private right of action. So we've got a litigant, the state attorney general, saying, we don't think this is covered. We think that the law as it stands is going to exempt this type of message, which gives us some, I think, good basis to think, well, the state won't be coming after me. But it doesn't do anything to prevent some other litigant from coming in and saying, well, this has never actually been litigated and I want to try my luck. So the state of Texas has enlarged the number of people who can file a lawsuit And one of those people who can file a lawsuit, the attorney general, said, we don't think this counts.
So thinking that through, there's a little bit. I mean, people, like you said, people are sort of celebrating the statement from the Texas AG, and it is a positive thing, but it doesn't really settle the matter because, as you said, they're just one of the parties involved, and none of this has actually been decided by the courts. So while it doesn't sound like Texas is likely to sort of go after anybody for SMS related marketing violations because of that private right of action, other people could, in theory, still do that. So to me, it's an open question. How does a company even answer the question of do they follow the registration and bond requirements or not?
Oh, that's a good question, and that may depend on who you are and where you're from and what and exactly what you're doing, which sort of gets back to the disclaimer at the very beginning. A lot of this is very fact intensive. One thing I will note is everybody gets all up in arms about the $10,000 requirement that
The
exists
security
under the
bond, yeah.
telephone solicitation,
Mhm.
but that's a bond. That's basically like insurance. You have insurance on your car; it's for $25,000, $30,000 per incident, and you don't pay $25,000 or $30,000 a year in order to have that insurance. Well, with a bond, you pay a bond company, which is basically like an insurance company, some small amount of money. You look at all of those type of things and you kind of make a decision, does this make sense for us? If you're sending SMS marketing and you're in Texas, I think it probably makes a lot of sense to just go ahead and do it. Then everything is sort of copacetic and you can move forward from there. If you're sending messages to a ton of people in Texas, it might make sense to do it anyway, even if it's, because this law, this telemarketing law, doesn't just cover businesses that are in Texas, it's covering people that are basically phoning into people in Texas. So it will, cover call centers in New Jersey and whatever, because there is a significant relationship to Texas. You're making phone calls to Texas, you're doing it. And so it makes sense that the Attorney General of Texas would say, hey, wait a minute, you're breaking our laws. It may make some sense to do that if you're a company in Texas or you're sending hundreds of thousands of texts to Texas, then it may make sense then. But other than that, it probably doesn't make a lot of sense. But you want to talk to a lawyer about exactly what you're doing and how you're going about it in order to make that determination.
And I think the one takeaway here that I really want to hit on, that the E-commerce Innovation Alliance's lawsuit has not settled anything in front of the court, right? With the court has not settled anything there.
To your point, this statement or the series of statements that we're talking about were filed in the state's opposition to a motion for preliminary injunction. In other words, the E-commerce Marketers Alliance said through their attorneys, we've got a whole bunch of people that are depending on doing this. These are some really onerous requirements. We don't think that they should apply. We think that the law should not apply to us for various reasons. And we want to keep things the way they are while we're going through the court process. So they're asking the court to basically say, we're going to keep the status quo. They can keep doing what they're doing. They don't have to do all these other things that the law requires. And the state is responding to that motion for preliminary injunction. So there hasn't been a ruling on the motion for the preliminary injunction. There hasn't been a ruling on the case overall. So the judge hasn't had a chance really to make up his mind about anything.
All right. I think that's a good place to leave it for today. So thanks, Mick. Thanks for breaking that down. I appreciate you. Everybody, this is Mickey Chandler, who is a lawyer and very smart about this type of thing. Keep in mind, he's not your lawyer. I'm Al Iverson. I'm not a lawyer at all. I'm some guy who just has a blog and occasionally makes videos. So thanks for watching, and please share this with others if you like it, and leave your feedback and thoughts in the comments below.